You signed a deal. The scope was clear. The budget was agreed. But suddenly your contractor starts changing terms, skipping parts of the job, or simply ignoring your instructions. Don't worry, this is more common than you think, and the good news is, you're not powerless. In this video, I'll walk you through what to do, step by step, when your contractor breaks the agreement. Welcome to the Property Investing in Real Estate series. I'm your host. If you're new here, this is the channel where you'll learn how to turn your 20s into your 20s. Before we start, click on that subscribe button so you don't miss any future updates. Let's dive right in. 1. Identify the type of breach. So first, try to figure out what type of breach you're dealing with. Is it a minor breach or a major breach? A minor breach is something that affects the overall intent of the agreement but does not totally defeat the purpose of the contract. Examples would be delays in delivery of the materials, slight deviations from the agreed-upon design, or incorrect workmanship, which could easily be. On the other hand, a major breach is when the contractor skips a major item in the scope, shows poor workmanship that affects the structural integrity of the property, or makes unauthorized changes to the plans and specifications. Now, identifying the type of breach helps you understand how strong your legal standing is. It also helps you know what your options are and how you should proceed. 2. Document everything. Before you confront your contractor, make sure you have all the evidence needed to support your claim. You want to have 1. Copies of the original agreement or bill of quantities. You need to refer to the original scope and budget that was agreed upon. 2. Screenshots or photos of the defective or missing work. Take photos of everything. Take photos of the actual work done, especially those that are defective, and take photos of the items or scope that were supposed to be delivered or completed, but were not done. So this is very important. 3. Written communication. Keep track of all text messages, emails, or letters that show that you gave instructions to your contractor, or show that there were broken promises on the contractor's part. All these documents serve as evidence. They help establish what was agreed upon and what was not done. They also serve as basis for your next course of action, especially if you decide to escalate the issue. 3. Issue a formal written notice. Don't confront your contractor in a fit of anger. Don't argue with them on site. Instead, take a calm and reasonable approach. Sit down and write a formal letter or email, stating the following. 1. What part of the agreement was violated? For example, was it a delay in the delivery of long lead items? Was it a deviation from the approved plans and specs? Cite the exact portion of the agreement that was violated. 2. State the exact issue. Describe exactly what happened. If it's a delay, state the agreed date of delivery and the actual date of delivery. If it's a defect, describe the defect and show photos. If it's a deviation, state the deviation and explain why it's a problem. Give a clear deadline to correct it. Usually, it's anywhere between 7 to 14 days, but depending on the severity of the issue, you may shorten the period. For example, if the issue involves safety concerns or imminent danger, you may shorten the period to maybe 3 to 5 days. This is very important because if you decide to terminate the contract later on, this written notice serves as a basis for your legal action. 4. Offer a resolution window. After sending the notice, wait for a few days, maybe 1 to 2 days, then call up your contractor and ask how they plan to correct the issue. Now, contractors who value their reputation will usually respond well to this. They will likely suggest a plan to resolve the problem and will ask for another chance to correct the mistake. If this happens, agree to an extension if you're satisfied with the solution they present. 5. Escalate. Mediation or termination. Now, in case the contractor doesn't take any action, you can choose to either terminate the contract or escalate the issue via mediation. Now, to terminate the contract properly, follow these steps. Step 1. Prepare a termination letter. This letter should state the reason for termination, which usually is the contractor's failure to comply with the agreement, despite a prior written notice. The letter should also include a statement that you are terminating the contract due to their breach. 2. Return all unused materials to the contractor. This is important. So before the contractor leaves your property, make them take back all their tools and unused materials. Make sure you inspect the materials being taken. If some materials are already damaged or unusable, take photos and annotate them. Make sure you also keep a copy of the official receipt of payment for these materials. 3. Settle all financial matters. Once the contractor vacates your property, settle all financial matters. Give them all the payments that you owe them for work that was done, as well as for the unused materials that they took. Get a clearance from them that they owe. You won't be filing any lien against your property, and make sure that all of these transactions are reflected in a final receipt. By doing these steps, you protect yourself from any future claims or liens from your contractor. Now, if you decide to escalate the matter through mediation, you can go to the barangay, the HLURB, or the small claims court. depending on the nature of the issue. Usually, the barangay is enough to resolve most issues. However, if the amount involved is large, you may want to go directly to the court. Final tip: avoid this next time. No. 1. Always sign a detailed written contract. Never rely on a verbal agreement. Even if it's just a renovation or a small project, make sure you have a written contract. This protects both you and your contractor and prevents misunderstandings. No. 2. Include penalty clauses. You may include penalty clauses in your contract for late deliveries or for defective work. Now, penalties must be reasonable and proportionate to the breach. For example, you can include a penalty clause that states that, for every day that the contractor is delayed in delivering the project, he will be penalized a certain amount, say 1,000 pesos per day, or that for every defective item he delivers, he will have to pay a certain amount, 5,000 pesos per defective item. Now, these penalties should not be considered as liquidated damages. They are only meant to encourage the contractor to deliver the project on time and to perform quality workmanship. No. 3. Pay progressively based on verified accomplishments. Never pay your contractor in advance or in full before he starts working. Instead, agree to pay him in tranches based on the accomplishment of specific milestones. For example, you can agree to pay him 20% of the total contract price upon signing of the contract. Then you can agree to pay him another 30% upon completion of the foundation, works another 20% upon completion of the structure, 10% for the enclosure of the property, 10% for the interior finishing works, and the last 10% upon final acceptance of the property. To avoid any confusion, make sure that each payment milestone is clearly stated in your contract. Emotions run high when it comes to our homes. We spend so much time, effort, and money in building and renovating our houses. So it's natural to feel excited, emotional, and at times overwhelmed. Plus, we tend to put our trust in other people when hiring contractors and designers. But remember, stay professional. Your house is too important for shortcuts or broken promises. Thank you for watching. If you found this video helpful, please share this with friends who might benefit. And until next time, happy investing.